Welcome to Clause 8, the #1 podcast on intellectual property, trusted by top in-house counsel, judges, and policymakers worldwide. Hosted by Eli Mazour, we bring you in-depth conversations with the personality shaping IP. Brought to you by TradeSpace, where ideas take flight.
Welcome to Clause 8, the voice of IP. We have a very exciting episode today with three of my favorite IP journalists who joined us when we finished recording the last season of Clause 8. It was right after Coke Morgan Stewart got named as acting director. You know, seems things were happening. We didn't know what's going to happen at the USPTO, the rest of the administration. But over the last 6 months, so much has happened in an instant. And I'm like, how are we going to restart this season of Clause 8? And the only way I could really think of doing it is to have all of you on to kind of share what you've been thinking about and share what you've heard others thinking about. So Eileen, Dani, and Michael, thank you so much for joining Clause 8.
Of course.
Thanks for inviting us.
All right, well, before we jump in, I guess, you know, I love reading your work, and I kind of have been following it for a while, but I thought for some of our listeners, it'd be fun to kind of get a little bit of your perspective on our field and kind of what's your vantage point and kind of what you do. So Eileen McDermott, the editor-in-chief of the IPWatchdog. I'm sure most people who listen to this have heard of that and read that, but can you tell us a little bit about that and kind of what's your...
Yeah, sure.
How do you do what you do there? Yeah.
Hi, and thanks again, Eli, for inviting me. I've been with IPWatchdog since 2019 now, and before that, I was with Managing IP Magazine for a long time. I was in-house with the International Trademark Association, both very different roles than IPWatchdog. IPWatchdog is kind of a unique sort of model. It's this hybrid of a blog that Gene Quinn started just because he is a passionate patent attorney, and he started just sort of talking about what was going on in his field, and at a time in 1999 when, you know, people weren't really doing that so much, and so people really started listening, and it has now kind of evolved into more of a news publication. And, you know, Gene is still sort of the person that a lot of people go to. So in terms of like, you know, stories that come to us, it's a mix of people coming to me, coming to Gene, with sort of insider info. And then we do a lot of events lately, and that's, you know, Gene hired me so that we could sort of expand that side of the business, and just going to those conferences and our annual meeting, and then the smaller events that we do throughout the year is where, you know, you talk to people and you hear a lot of, you know, the panels that we do are very kind of discussion format. People feel kind of safe they're not all on the record. And so you hear things. And so that's kind of where, that's how we get our information. Gene's very connected and has been in this business for quite a while. So it's a fun place to work. It's a fun format.
And IPWatchdog does have some of the best conferences, really fun people, very diverse. But it's also kind of reflects the readership of IPWatchdog, right? You have everybody from person wondering about how do I get a patent to probably the person who knows everything that's going on in the patent world. I guess, how do you think about like, hey, this is worthwhile, this is what we should kind of be sharing with our readership? How do you kind of think about that?
I think we're always writing for the person on the hill, maybe, who, like a staffer who might not know anything about IP but needs to learn about it. And so I think it's always best to write for the person who knows, you know, the least, so that it's readable and digestible to everybody, and still cover the hot topics that everybody's interested in. But I think our audience spans, you know, general counsel, patent attorneys, inventors. We have a very big inventor readership because Gene was very involved with the inventor community for a long part of his career. And
it's free to access, right? So
and we're open. Yeah. So we're one of the last sort of, open non-subscription based models. And so I think everybody is our audience is everybody, but I think that especially I think that the Washington and people on the Hill are listening a lot to IPWatchdog.
And reading at the Federal Circuit as well. Thanks, Eileen. Dani Kass, she's the senior reporter at Law 360. Hopefully I'm getting that right. I guess, can you tell us about Law 360 and about your work there, and how do you kind of, how'd you end up in this IP thing?
Sure. Thank you for having me. So I've been at Law 360 since 2015 and covering IP exclusively for about half that time. I've always just found it to be just a really intellectually stimulating part of the law. It's very funky, and a lot of reporters are just like, I would like to be on any other beat than this. Whereas for me, it's like, no, wait, this is really interesting, and it's one of like the better attorney communities. So obviously we are not open. So our readership really is the IP community, but we still try to make things accessible when we can, getting into the weeds without having to speak like we're in the weeds, and try to figure out how to make that accessible while still understanding that our audience is very sophisticated and they're people who are already in the thick of it. So it's me, and there's a team of about 2 other patent reporters and another senior reporter focusing on copyright and trademark. So it's a really good bunch of people.
And when I reached out to Dani, I said some of my favorite work from you was some of these offbeat stories you've done. You've gone on an airplane, I think, with a patent litigator from Texas. You've visited Judge Newman, I believe, in her apartment. I guess, can you tell us about that? Like, you really get to kind of focus on people as humans versus just, people who do patent law. I guess, how do you decide to do that? I guess what anything stands out to you from all those experiences?
So I have to burst your bubble a little. I did not get to go on the plane. The conversations were all over the phone. And I only saw Judge Newman in her chambers.
Yeah.
I feel like I'm ruining some images right now.
Yeah.
But no, it was getting to actually meet and interview Judge Newman was fantastic. I had reached out to her several times before to just, want to interview her about, she's a really powerful woman and who, kind of joined this really male space a long time before that was, even on the radar of most people. But she's always had a blanket no interviews policy. So when this came up and she was ready to be interviewed, it was really nice to get to go to her chambers and get to talk with her for, an hour and a half. And there was no one else in the room. She was just very much like, okay, we're going to sit down and talk. I don't need to have, my lawyer with me. I don't need to have a colleague with me. It was just very, she was just very easy to speak with.
And before we get to Michael, I guess I want to have Eileen, because I know since Judge Newman, I guess, has been going through all her, legal troubles, that she's been more out and about, kind of speaking her mind. And I know she's come to quite a few IPWatchdog events, and you've covered that. Eileen, what anything kind of stands out to you from all that?
I actually, the first time I met Judge Newman, totally dating myself, was 2008 when we gave her the Lifetime Achievement Award at Managing IP magazine.
Oh, wow.
And so she's, a really great trusted friend of Jean and Renee. They see her a lot because they're down there. I think they do lunch with her often. And she's come to so many of our events. She was on a panel that I moderated at our last conference. And she's, I think that there's no question that, she is cognitively 100% there. And so it's troubling to see what she's going through, right now. So, but she's wonderful to talk to, and she's a great friend of IPWatchdog. So,
last but not least is Michael Shapiro. He's also a senior reporter at Bloomberg, and I know Federal Circuit is part of your beat. So I don't know if you want to jump in with your thoughts about Judge Newman, or just tell us what you do at Bloomberg first. But
yeah, I'm just happy to be listening to this episode if I wasn't on it. So thank you for having me. This is fun. Federal Circuit is the main part of my beat. So I cover the court. I go to arguments. Often the only person who's not a clerk or on one side or the other at these arguments, and it's been a really great education. I know that I'm newer to writing about patent litigation than either of your other guests here, so try to read up and learn fast. But my background, I was a journalist at newspapers covering county government and transportation projects that were shutting down a lane of the highway for a couple months, really small stuff. I ended up going to law school and practiced as a media lawyer, not doing patent work, not having much idea of what a patent was, or the case law or rights that developed over centuries. And like I said, I try to know what I don't know, which is a huge amount, and it's been fun to learn about this little pocket of the law.
Yeah, I think you had an interesting career. So you were a journalist, and then you decided to go to law school. You were a lawyer for a short time, and then I guess you couldn't stay away, so you went back to being a journalist. But I guess anything that being a lawyer gave you perspective in terms of like what's relevant to lawyers, what kind of information it is that you kind of think about now, that experience kind of?
Yeah, well, either I couldn't stay away or I couldn't hack it. I don't know. I don't know which it is. Being a lawyer, being a litigator, helps me do docket research, and I kind of know what a civil lawsuit looks like and the type of thinking you go through when you're drafting a complaint, and the federal rules of civil procedure, and you work through them over the course of a case. Although you're right, I wasn't maybe a lawyer long enough to really be an expert in any
I
of
didn't
these
mean
things.
to ask a leading question, but
No, I mean it's helpful at times.
Yeah.
I didn't work in patent law, so I think both Dani and Eileen have talked about writing for maybe different audiences. I tend to want my writing to be intelligible to somebody who's not maybe a patent person. And so I don't know, I'll describe patent prosecution as the patent application process, or try to have some shorthands for some of these things. Because believe it or not, if you haven't been in this space for a while, people are confused at some of the terminology.
I don't want to, I guess, get this wrong, but I remember actually when I interviewed Judge Dani, just remembering talking to Judge Newman reminded me of interviewing Judge Dyke in his chambers. And I remember when I came in, he had this big stack of printouts, and he said, we have some service that collects everything that everybody writes about IP, and I read it all. And I was surprised because, he's making the news. So I thought, maybe, he wouldn't be spending his time reading all the coverage, but he is. And I'm sure all of you are aware to that to some extent. I guess, how does that impact what you do? And I'm sure there's a lot of people out there who maybe have a case before Judge Dyke or something like that. They want you to write something that he's going to read, right? So I don't know, and I'm sure there's situations like that as well. So I don't know, maybe Eileen, since you brought it up, that the audience in DC, like, how does that impact? You're saying the thing that you write is to educate them, but how does it impact the fact that they'll be reading it and might make decisions based on it?
I guess I don't focus too much on the judges or what they're, not the Federal Circuit judges. I mean, we have a small staff, obviously, and I am writing, focusing on mostly the precedential decisions out of the Federal Circuit. And I think that a lot of our audience, like the mainly attorneys, are really want to know what the court is doing from a precedential perspective, and so that's where, in that sense, when I'm covering the Federal Circuit, where I'm kind of writing to them, but with the only time, I guess, like when, in terms of all this stuff, all the drama that's going on at the Federal Circuit with Judge Newman's case and those, I mean, that's a little bit more where I've gotten in my head, like, that the chief judge is reading this and probably not really that happy, but but yeah, I don't know if that answers the question, but
it does, yeah. And I guess, Dani, how about you? I know you're, I guess.
It's very interesting every time you find out that judges are reading your writing, because it's just, you don't think about it. And I definitely don't write for them, but it's nice to kind of, like, it feels like a level of responsibility of knowing that you could help write something that shapes the actual decisions. Not that I think, our stories really will much, but it's still, part of the conversation. So I think it kind of has a level of accountability with it. It's also, stuff with Judge Newman. You go and talk to her, and she is very coherent. It's like there's nothing wrong with you. Like, this is really easy. But knowing that, like, okay, the rest of the Federal Circuit is reading this makes me think, like, why am I making assumptions? Like, what is happening behind the scenes? I can't know everything based off of a 1-hour conversation. It's the party that I get to talk to. And so it kind of, like I said, makes you accountable to remember that, like, what the bigger picture looks like and how to keep things fair. I will say, though, that kind of having some name recognition, which is very strange, helps that, if you want to reach out to somebody for a question, like on the record or not, you have a lot easier access. When I feel like there's been times where I've messaged judges just like very randomly, and as long as they're not Federal Circuit judges, they are normally, answer right away, which is a very cool experience to have. Federal Circuit judges just tell you to go to the press office, which is fair.
It's interesting. You get to find out about people and organizations by how they react when you contact them, talk to them. Michael, you said you spent a lot of your time on the Federal Circuit. To me, when I think of Federal Circuit, some names stand out, obviously the Chief Judge and the news, but there's so many judges, so many cases. Like how do you really cover that? How do you kind of decide what to focus on? How do you decide on what you should be following and what judges? Obviously, there's a lot of conversation about whether, judges have panel dependency and all that, but there's so many individuals in so many cases. I guess, how do you think about all that?
For starters, I can filter out a pretty big chunk of the caseload because I cover patent litigation. And so veterans cases and MSPB appeals, and there's a lot that they do that I don't write about, and maybe other people do. I don't know who covers appeals up in the veterans courts, but that helps. But I also cannot focus on every appeal in every patent case. And so I read a lot of briefing at various stages as things come in, as new cases are docketed, as things start to pop up on the oral argument calendar. I also have some sense of what my colleagues are writing about from the district courts. And I have, some amount of email that I get from readers or lawyers, litigators, about what they find interesting. And I'm really interested in kind of bigger themes of whether there's debate between the court.
Interesting. You said, I guess you get a lot of emails from litigators. Are they trying to hey, my case I won is really good, or what's the nature of that, or the Federal Circuit is getting wrong on this issue? What is kind of what do you think motivates people to take time to email you?
Sure. There are law firms that will have PR people who reach out only after they've won a case, I'm sure, and maybe you didn't even know it was happening, and that's fine. I get that. You want to celebrate your wins. I would say more often with sources and people who are practitioners, they're less inclined to reach out to me about their own clients and cases, and maybe more likely to be watching something that's something they're excited about, that's a litigation angle, strategy, or something they're concerned about from the other side of the bar that they think is problematic in some way, in either direction. And those are the kinds of things people reach out to me about. To the extent that any of the Federal Circuit judges watch your show, I talk to people on background and off the record all the time, Eli, so they can feel free to email me anytime they want. I've only actually spoken to a few of the judges on the court, and they've all been very nice and gracious. But Dani's right; it's maybe an insular group.
There's a cynical theory, not that I've stated no opinion, but some people look at a Federal Circuit decision and they say, hey, it came out that way because this was the name of one litigant and that was the name of the other party or whatever. But I guess I'm curious from a coverage perspective, does that play a big role? Because if it's a famous company, then it's more relevant. Or I guess how does that play into, Michael, the cases you follow?
Yeah, if there's a Fortune 500 defendant, we have readers who get my contact. I'm at Bloomberg Law, but our content goes out on what's called the Bloomberg Terminal. So anybody who invests in the stock market professionally can read stuff that way, and we do maybe focus a little bit more on if it's either a really big verdict or a really big defendant in a case, and those two things go hand in hand usually. I am still going to be interested in a case that is between two small companies with some really interesting legal issue, and I would not say that the company names guide my decisions most of the time, but maybe in a tiebreaker, if there's a big name defendant, sure, well, maybe I'll be a little bit more aware of that case.
Yeah, no, that's interesting about the Bloomberg terminals, because obviously there's a lot of ups and downs in patent litigation with verdicts being wiped away and all that. So, Dani, I think all of you do this. Obviously, you talk to a lot of patent attorneys. And I think you've covered as well, obviously, some of the things that's been going on with the administration, from the last administration to coverage. I guess, can you share, what is your sense? What is the mood in the patent community now about anything that comes to mind? And I guess compared to all your other years of covering, yeah.
Mass confusion, ton of frustration. I think it's just a lot of people who are like, I'm trying to keep up with what's going on and it keeps changing. And so, how do I make sure that what I'm doing today is still going to work in a week? So that's a lot of what I'm talking to people about. And in terms of, if people are happy with, the way the patent office is going, with the PTAB, how many cases they're accepting, kind of what the priorities are. That's just kind of the standard, back and forth that you get with, most administration changes or most director changes. But I know people are also really curious to see what's going to happen if/when John Squires comes in, and what kind of role Coke Stewart would have as deputy director. Like, is she still going to be issuing 500 director discretionary decisions every week? I think that's a lot of what's on people's minds, and also how is the USPTO going to continue functioning the way it is with decreasing resources and decreasing morale? So those things.
Yeah, I would agree. I guess it's, I think you don't hear the worst of it. I think people are a little, afraid to be very vocal, but it's, people are always frustrated. In the last administration, people were very frustrated with Kathy Vidal and the rules packages and the confusion around that. But, right now, I think with, Coke Stewart is taking like a very a Trumpian approach to the USPTO, and understandably so. But I think it is causing a lot of people to be a little bit concerned and frustrated. And the question is how is that going to change when there is a director in place, if it changes or if it becomes more exaggerated or it pulls back. I'm not sure yet. Yeah.
Will Covey, who's the acting deputy director at the USPTO, he spoke at the one events, and you wrote an article. Somebody actually mentioned it to me yesterday, and it was about him talking about getting back to basics. And I think he was trying to reassure, the patent bar that, we're just trying to fix things, but everything will be good. I guess, what was your takeaway from that? And do you think, I guess the question is, the big problem is the backlog, right? The backlog at the USPTO.
Yeah.
And he was talking about how they're making all the examiners focused on getting through this backlog. That's back to basics. But it's not going to be permanent. This is just a temporary solution. So I guess,
I think that's working to some extent. I mean, it is. I think we just reported on comments that Koch made at a recent conference, and not our conference, a different conference, and the backlog is down a bit. And I mean, what she's doing is going to work, right? Because it's she's creating less work in some sense, and they're also employing tools like AI tools and stuff. I'm not quite sure how those are working exactly yet in practice, but there's a lot of stuff that could work. It's just I guess whether it's a long-term solution, whether it's viable long-term. But I think that's definitely the message that's coming out of this administration is bring your challenges up front, strong patents up front, and get back to the basics of, have a strong patent from the get-go kind of thing.
Yeah, I guess they're related, and I don't know if any of you want to weigh in, but I guess there has been some coverage in terms of the morale at the USPTO. I guess people don't think about it, but there's 10,000 patent examiners, and there's a lot of people who kind of there, and I guess what does the impact all of that have? And you've heard political appointees from a previous administration. I think I read in some of your publications come out and say they're messing everything up. I don't know. How's that part of the story has progressed, and has that surprised any of you how vocal, I guess, Kathy Vidal and others from her administration have been?
I mean, I just know Bob Stoll spoke at one of our, the former commissioner of patents a while back, but at one of our conferences, at our annual meeting actually in March, and said that morale was really bad. I mean, that was early on. I don't know what is happening at the moment. There's obviously, a question of attrition under the current, scheme, because there's already, I think, a pretty high turnover of patent examiners at the USPTO on a regular basis. That's just how it's always been. But, whether if people have to work in office, return to in-person work and things like that, whether that's sustainable for an agency this big and sort of expansive. So I hear, hearsay kind of that people are unhappy, but then you hear the opposite story from, some of the higher ups. So who knows?
Any hearsay that you want to, Dani or Michael, share? It's a podcast, so that's.
Well, I think I told you I try to know what I don't know, and I am probably less plugged in than either Dani or Eileen on the pulse of morale at the patent office right this minute.
I think Michael, me and you kind of discussed it, but I guess part of our readership is our people, I guess, in the business world. anything that I guess you're thinking about, or obviously the big topic has been litigation funding and all these new patent models. Anything that you're kind of hearing or following that you think is interesting from that perspective?
Well, absolutely. The changes to kind of the screening process at the Patent Trial and Appeal Board is just hugely important for whatever side of that you are on, whether you think it's the greatest thing since sliced bread or really detrimental to your business because you're going to be having to defend more patent claims in district court. That's going to be challenged. The first fintive factors are subject to a challenge. It's now pending at the Federal Circuit, and there are several mandamus actions as well that are more targeted to the latest rollout of what we call discretionary denial processes. I won't call them rules because probably that's even being argued whether they are or aren't rule-like. Yeah. And I try not to weigh in either direction. But that's going to be a huge story. It's millions or billions of dollars are at stake across the whole patent system. And yeah, it affects everybody.
I said the reason I wanted to have you on is because so much news happened before I decided to have you on, but the news somehow didn't stop after that. One of the big stories that everybody's talking about now, and we're recording this on August 8th, is the Wall Street Journal report about Commerce Secretary Lutnick considering proposals to charge patent owners 1% to 5%. When I saw the report, I was skeptical. And then as soon as I think I put something on LinkedIn, people reached out to me who know better than me. They're like, "You're wrong." That is happening. And I guess he's going around and actually sharing the idea and reporting it. And then I actually heard something else from there's something circulating at the USPTO's finance department, very high level, but I guess they want them to look at, some kind of numbers about what would happen with his idea. So that was happening. And then Coke Morgan Stewart just, she confirmed as much at the conference that I think maybe Ali was referring to. And I said, Dani, you helped report a piece out on that yesterday. I guess what was your takeaway from that? From the whole story and then from, what she said yesterday.
As far as the Lutnick patent tax story, Gene wrote on that, and I think he called it catastrophically stupid in terms of an idea.
He has a way to really encapsulate things, yeah.
Within his words. I haven't heard anybody say that it would be a good idea, really. Like, I've heard some people say, maybe that could work, but I don't know how it works in practice. You probably know more about how you actually value a patent. I mean, I don't really know. That seems like an extraordinarily complicated idea to me, but maybe there is an easy way to make it work. Gene seemed to think that it would be, it would come to be in the maintenance fees and patent maintenance fees at 3, 7, and 11 years or something. So I guess you conduct some sort of valuation at each of those stages. I don't know. I'm not sure if anybody thinks it's a good idea, but
it's an interesting story because there is this sort of sense that it's a monumental task. Patent prosecutors I've spoken to seem to be the most alarmed group out there. Eli, you can confirm whether that's sort of fits with your experience, but
maybe that's just their nature. I don't know.
Yeah, well, I don't know. I think it is interesting that we have a commerce secretary who, he was a broker dealer, right? Somebody who was in the business of charging some small percentage on every transaction, and maybe we're charging some small percentage on the value of a patent. But as Eileen is saying, how do you value a patent is a really complicated task for one patent, and for 2 million, that just becomes a really it's a project, and I think that might explain some of the skepticism out in the patent law community.
What do you think of it, Eli?
Well, yeah. I guess I also I don't think it's going to happen. I guess that's the bottom line. And I think some of Cook Morgan Stewart's comments yesterday were I understand her, she has to she has to defend what's whatever is above her in the administration, but she basically said, don't focus too much on details. We're just discussing these things, throwing them out. And thankfully, as most things that are proposed in government, they don't come to pass. So I think that's where we are with that, and I don't think they're gonna. I guess there's no practical way to do it, but who knows? Maybe there will be some bad idea built on that, but based on that. But so you never want to keep your guard down. But I did. I guess speaking of Bloomberg, I guess I was talking to somebody in the pharma community, but the one thing that stuck out to me is it was reported in the Wall Street Journal. A bunch of stocks went immediately down, and I'm like, and it's just funny how things were. I'm sure there's like people who tangentially follow pattern news. You might, make them make some decisions based on stuff like that they wouldn't. I mean, the one community that I've sensed some enthusiasm are, I guess, say you might call them patent owners, but who've had troubles enforcing their patents, maybe like small-time inventors and stuff like that. And it seems like to them, it's an opportunity, If I can guarantee that my patent will be enforceable 100%, then, 1 to 5% is not bad. So I'm sure there's some who'd want to make that trade, but I think actually the biggest patent holders are, the big tech companies who never enforce their patents, and I guess it'd be a question to them if they'd want to have so if they'd be just getting punished for obtaining patents. I don't think they'd be interested in doing that. All right, so I this is a story that I guess kind of stuck out to me. Any other big stories, Dani, that you're kind of following or thinking about?
I feel like half my brain right now is taken up by discretionary denials because they are moving so fast and the law is changing so fast. We've been trying to keep a very detailed record for people. I like creating things that are resources that, attorneys can turn to and be like, something super complex is happening. Let's lay it all out in one spot. And so trying to keep up with those week after week so that way people can, try to figure out like what are the current statuses of things, in terms of how should I be drafting my petitions going forward? Should I be drafting a petition? How did things change from last week? Because suddenly you can't challenge a patent that's 6 years old. How do you go about that? So that's kind of been the main thing that I have been focused on. Obviously watching for the director confirmation and, whatever is coming out of the federal circuit, whatever, they decide is going to be the next fun thing for all of us to look at.
Yeah, and the first thing you bring up about, I guess, the changes at the PTAB, at the USPTO, I guess I do hear this narrative that, attorneys don't know what to do, it's so complicated, but I don't know how much of it is that people don't like the changes or it is that way. So I'm not, so Dani, what is your impression, I guess, from covering it?
I think that the frustration over the changes are separate from the frustration over what they could mean. Yeah. I think people trying to keep up with what's happening are just like, how do I, do this when suddenly something is happening, and it's no longer the same as it was yesterday. And for some people, that is great in terms of, what happened yesterday is better for me. And for some people, it's like, this just made things worse, but it doesn't change the fact on either that, like, the petition you drew up today might have to be entirely redone tomorrow.
Michael, you mentioned some of the Federal Circuit, I guess, appeals going on related to fintech factors. Anything else, I guess, any other big stories that you're kind of thinking about and following or interested in?
So I know I'm repeating myself, but really the interplay between PTO, PTAB, and the acting director right now, and just the Federal Circuit, which may or may not curb her discretion that's just a huge story and is top of mind. I'm sure there's some other things that are going on that I'm tracking that I'm forgetting. But,
Yeah.
but that's story number 1, 2, and 3 right now.
For me, I mean, it's a lot of what Dani said in terms of stuff. We cannot keep up with the number of cases that are coming out on the discretionary denial. But that's obviously of interest. So I try to, when there's one that, contains a new fact, like there was the other day, there was a decision where I think it was the youngest patent, that was just 6 years old, that got the benefit of the settled expectations doctrine. So we'll try to report on those kinds of things, but that's definitely a big one. But I really love, what's happening in Congress and following, some of the bills, and even at the administration level, one thing that I'm curious about how it's all going to pan out is the Trump executive order on most favored nation and drug pricing generally. Like that, it's sort of like patent adjacent, but it's very relevant to patent owners and the pharma community, because patents do get blamed for drug prices directly. And so it's something that I pay attention to, and that at the pharmaceutical community of our readers, they're very interested in that topic. And I find it fun to cover that kind of stuff, the policy side stuff.
You mentioned, obviously, like your audience, when you think of your readership, you think of the Capitol Hill staffers. You mentioned following the bills on there. So I'm curious, I think we all know, the big bills were circulating, I guess the 101 bill, the PTAB bill, and I guess the injunction bill. And it seemed like there was a lot of enthusiasm in the beginning of this Congress. And then Senator Tillis announces he's retiring. I guess, Eileen, have you heard anything that you kind of think, how's that all going to shake out, I guess?
I mean, not directly. There may well still be people who are going to take up that torch, I think. Coons is very much a part of that and will be around. I think there's just way too much going on. I don't know when those bills will come back to bear. And it's, I think it was a long shot anyway, even though they did move pretty far in the last session. But I think whether they're going to be reintroduced, they might be reintroduced, but in terms of them passing, I think it's questionable. There's a lot of other stuff that people are interested in right now. So I don't know. I haven't heard anything specifically.
I would pay more attention to Congress if I thought either the defense bar or the inventor side folks had the votes to do anything.
Yeah.
I think it is interesting because there's messaging about what changes and reforms there should be to the system, and there's a lot of hard work that goes on, and I don't take away from that at all. The hearings are interesting, topics are interesting, and where different members stand, to the extent they are in the weeds at all on patent law, is interesting as well. But I think the House committee and the Senate committee are just politically in different places, and it amazes me to some extent that there was such kind of a huge legislative change back in 2011, because we're so far from it now. It's like, how could that have how could they have gotten all these people?
It took ages, though, right? It took
and that was forever and ever, and there were a lot of things that motivated it.
And I guess when you say that they're in different places, the House and the Senate, you're saying there's not a lot of activity in the House. Is that kind of the?
Well, I mean, the bills that I think we're talking about, some of them got passed out of committee on the Senate side.
Yeah, prevailed.
But I don't believe correct me if I'm wrong. I don't remember.
No, you're correct.
Maybe even them getting a hearing on the House
Y-
committee, and they would need to if those were going to become the law.
Yeah, I think we're still looking for enthusiasts. I think there's also a dynamic, obviously, in the House where the chair of the IP committee is not a fan of these bills. So
Right. Yeah. I think Congressman Issa sees things differently from Senator Coons or Senator Tillis. And Tillis is retiring. Coons is no longer ranking. So there's been a lot of change on the Senate committee.
yeah, and when I interviewed, actually John Lee, who's advises their lives on these, I guess, on IP issues, he said that for anything to happen, all four members of Congress from both sides have to agree on something, and I guess that's difficult in this dynamic.
It could happen, and we should pay attention to these places because there's a lot of power there. But so maybe I was a little cavalier at the start of this conversation, but
No, you're right.
But yeah.
Yeah, I mean, I think some of that, and probably you see, I found interesting that the USPTO pays a lot of attention to what I guess members on the Hill want, and you see these letters going. But from what I understand, it's actually behind the scenes. Before they send one of these letters, they say, "I'm going to send this letter, but I want you to do this," and the USPTO then kind of pays away to do that. So they do have, I guess, an impact indirectly like that. One of the stories that I know all of you were covering and looking into and broke pieces of it, so dramatically, is the selection of the USPTO Director. But I want to talk about that, like, before we talk about, what happened this time around. I just find that whole dynamic kind of fascinating and interesting because you see all these names floated around, nobody knows where they come from, and then somebody gets chosen, and then you don't get really the full story about how all that happens. But I mean, from your vantage point, can you kind of share just what is it like covering the selection of the USPTO Director and everything that goes around that?
I got really lucky on this one because I didn't have to speculate for very long. Fortunately had, a lot of good sources who were able to clue me in very quickly to what was happening. So it didn't have to be too much of a guessing game. But it was just until then kind of, every time you were on the phone with somebody being like, have you heard anything? And there were, 3 or 4 names that kept coming around. None of them were Squires.
Yeah.
So yeah, it was pretty much just like constantly asking until somebody that you talked to enough was like, hey, I finally figured it out.
Yeah, and I imagine, I guess, you don't have to say anything about it. Reading your reporting, I guess maybe you've talked to people who are worried about it, about the selection, and others who might be happy about it. But you see this dynamic where obviously some people want their name floated because, their friends basically write about them, and they're like, who's this person? But I guess, do you get that a lot where like people are pitching you that they're being floated, or not maybe directly or indirectly? Do you get that or no?
No, the closest I got was that a PR person reached out to me and said, hey, this person at our firm has been selected, and he's available to talk today. And someone I knew already, so I called him and I'm like, you're the new director? And he's like, no, my name is just on a whiteboard somewhere. And I'm being considered for it. That was a very bizarre conversation. I'm sure that PR person did not have a fun night.
I had heard not that long before Squires was the nominee that Coke might really have a chance and that it might be her. And so it was a surprise a little bit, but yeah, and not too surprising when I think he's pretty good friends with Lutnick. And so yeah, it's but it came a little bit out of the blue for me. I hadn't really heard about him that much until it happened. So. And
Michael, I remember you had a very interesting post on LinkedIn, I think, where you were kind of sharing how your coverage, kind of, you were thinking about, and I think some aspects that, he was having these 4 people down in Mar-a-Lago. So you have some details there. And I actually ran into one of those people after your post, and he kind of confirmed it. But anyway,
I'm not I'll correct myself. I'm not sure they were in Mar-a-Lago.
Yeah.
Although somebody had thought they were,
Yeah.
and I that could be wrong. So happy to get on the microphone and point out my mistakes a little bit. But yeah, it's always interesting when you have a process where people are lobbying behind the scenes for themselves, and there are interviews happening, so you get to see how people behave in those ways. Maybe they're natural allies, but it's time to note that somebody has something wrong in their resume, or some reason we should focus more on me as the candidate. I don't know that I saw a lot of that directly, but it filters through, perhaps. And I think more so the patent community, again, is a little bit, this is not Supreme Court judge nominations, and it's a little lower stakes, even though this is obviously a career highlight to be a nominee for the PTO director.
Yeah, I was going to say this. It's interesting because I'm sure even within the administration, most people involved in that process, like USPTO director, what's that?
Yeah.
But to the IP community, it is a story. I mean, another aspect to that is that I always think about is that not just the selection, but then a lot of weight is put in, like, what are these person's views and what impact is that going to have? And they try to like come through that to see, how did him, I'm exaggerating, but how did him like signing his name on a patent application in 1982, what impact will that have on his views about pharmaceutical patents? But I guess, I know, Michael, you haven't been covered as long, but Dani and Eileen, you've seen it with other directors. Any thoughts about that, I guess? The role that whoever is chosen becomes a director, what they ultimately have and how things shake out in administration.
Yeah, I know that there's always speculation. I remember with Kathy Vidal, that was a concern, I think, in terms of her past life, her past career. But at the end of the day, it is very speculative because I think, the director does what the administration wants, and in almost every case. So it's very sort of, they're their own person to the extent they can be. So I'm not sure it's that useful, but it happened. It does. I mean, and I'm sure it's like somewhat relevant, and it's relevant if someone has a lot of experience in the IP space. But yeah.
Well, I started, exclusively covering this while Andrei Iancu was in office.
Oh.
And all I remember at the time was being like, this is great. It's somebody who knows what a patent is in charge of the office. This was not a guarantee at the time. And so I was like, we have a really special agency. There's somebody qualified. Yeah. But I, at the time, didn't really quite know the politics of the patent office. Like 2020, I got promoted like right after COVID, or like right after like initial lockdown. And so it was a very odd time to try to figure out the political environment. And all I knew about Kathy Vidal going in was that there was this concern about kind of having connections with tech and what that would look like. And so that's pretty much what I've heard.
Yeah.
Yeah. Everyone was very happy about David Kapos also. And I remember that being a big change. But yeah, and then, it doesn't always pan out, but.
And I guess we take it for granted that, I guess, since David Kapos has mostly been, I guess, patent attorneys, but before that, I think it was congressmen and others who had less of a connection to USPTO, and you think that's kind of a position that, so they might give to a donor who thinks it sounds cool. So it's so I guess we've been blessed. I guess the patent bar has been blessed from that aspect. So we're getting, I guess, close, and I want to kind of give each one of you a chance to kind of maybe share your thoughts. Just your vantage point, because I think I don't think any of you are patent attorneys, but you get to spend a lot of time with patent attorneys, kind of covering them and covering for them and all that. So any kind of anything you want to share, but I guess that just in case you want to from that perspective as well. So maybe we'll start with Michael, since.
Sure. You're just my impressions of 2 years, 3 years covering patents.
Yeah, or anything else that's on your mind. Yeah, your final thoughts.
I spoke with a federal circuit judge really briefly who said, when they're having oral arguments, they sometimes forget that anybody outside of maybe the parties is watching the case, writing about the case. I think sometimes I forget people are reading my articles, so being on the spot like this forces me to confront the fact that people pay attention to what we do, and it really matters. I find these cases, particularly the ones where the lawyers really try to explain the narrative and how the broader world might be impacted by their case, really interesting. I don't know if I'm answering your question, but it's been a lot of fun, and I've patent lawyers, they like to explain things. So I've been the beneficiary of some people who are really generous in explaining a complicated area of law to me. So just, if you're listening, thank you.
I'll agree with that. I feel like in terms of attorney communities that are willing to, help out, a lot of my colleagues, their emails from attorneys are like, why did you write it this way? Or why didn't you include the middle initial of my name? And just things that are like, can you change my quote to say this? Whereas the IP community, I can just call somebody, midnight to be like, can you confirm that this voice is, Judge Dyke versus Judge Toronto? They don't have similar voices, but when you're listening to the audio for the first time, or like, hey, this is such a complicated thing. Like, can you give it to me in the most basic of kindergarten terms what this patent covers? Because I am not someone with a technical background. Or even little things like, can you double check that I'm getting the procedure right in this like crazy complicated case? And you will find more support in the patent community in terms of attorneys who will talk to you on background than anywhere else. And the fact that it's so communal like that, and that everybody at the end of the day is a nerd more than the lawyer, kind of coming in with more of that. Not everybody, of course, but like there tends to be like such a nerdy community that I really like. And yeah, so that's also a call. Like Michael said, inbox is always open. Always happy to talk on background or off the record. Pretty good record of, respecting that.
Appreciate it. Eileen?
Yeah, no, I would agree with all of that. I mean, I've been around a while, and everyone is like a friend, at this point. And I find that some of the best sources and people that really helped me along the way are some of the people you would think might be the most intimidating. Like Judge Michelle is the best person to talk to explain something or to just give a quote. And he helped me so much as I was like learning on the job about IP and just explaining stuff. Judge Rader, people, the late Q. Todd Dickinson was also a big mentor of mine, and just so good at sort of distilling the information and speaking slowly and just really giving you the pulse of what's going on and being open about it. I mean, obviously Judge Michelle became a source after retirement and Judge Rader, but that once he was retired, he was like, I want to talk about everything all the time. So, and that's great. So yeah, I think that's an interesting fact that I've noticed a lot, is that a lot of the best people, the best sources and best people to talk to are really prominent people rather than like the first year attorneys, and I've just always found that interesting. So,
and I'll add that in this community, it's so strange. Like the first time you get a thing, you're like, oh my God, Dave Kaplos responded to my email. Like I have a former director. And then within like a month, you're like, oh, okay, I can just like call this person.
I know. Yeah. Dave is another one. He was the best to talk to when he was at the office. He was very good at also speaking slowly. I like people who speak slowly.
But just like the amount of like quote unquote powerful people who are willing to just sit down and talk with you all the time it's pretty abnormal, and it's greatly appreciated.
Eli, I don't know if we're allowed to. One other story that I wanted to like say that I am interested in, and I don't know if I'm allowed to talk about copyright here, but in terms
You
of
are, yeah. It's
everything that's happening
voice of IP, so.
yeah, everything that's happening at the Copyright Office with Shira Perlmutter and that I am very interested in finding out what the morale is there, because it seems like a little chaotic.
Yeah, and I guess we haven't gotten to it, but there was some, and I don't know if it's related or not, but there was some criticism of the AI guidance that came out of, I guess,
Yes.
there, all that. And at least I haven't seen a lot of coverage since that, if anything is going to change or not. But
yeah, I haven't heard a lot about it. So
I am, as Eileen hinted, I'm maybe too stuck in the patent world. So.
I took a look at that with Squire's nomination. I found him mention the word trademark once in like an opening statement.
Yeah.
And that has been it. And so if I was a trademark attorney, I'm so curious kind of what's going through your mind right now, although it's probably like we're used to this. But at least, with Kathy, like you were able to find like 5 or 6 references. It was just like once, like we want to protect trademarks. Nothing.
Yeah, I was saying actually about the Wall Street Journal story. Why patents? They could also charge based on the value of trademarks. Why leave it to patents? So, but yeah, I guess maybe it's a catch-all for for better or worse. Michael, anything else? I guess, or anything else you all?
Appreciate the opportunity. No, thank you so much.
yeah, thank you for inviting us.
Well, thank you for all you do for Dani, Michael, and Eileen for keeping the IP world informed, and I'm blessed to have gotten known all of you, and I really appreciate it, and thank you for coming on Clause 8.